to learn and work free from discrimination. Pursuant to Committee Rule 7C, opening statements are limited to the chair and ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. And I do want to note that at some point in the next probably half an hour, we will be breaking to vote and we'll be coming back. I recognize myself now for the purpose of making an opening statement. Today we are holding a legislative hearing on H.R. 5, the Equality Act, legislation to guarantee and expand civil rights protections for LGBTQ Americans, and I want to thank our witnesses for being here today. The struggle against discrimination in the United States is as old as the country itself. For generations, marginalized people have fought and sacrificed for the inalienable rights of life, liberty, and the pursuit of happiness to all Americans. The Equality Act is the next chapter in this story. From the raid on Stonewall in 1969 to the victory of marriage equality in 2015, we have made significant progress toward becoming a more inclusive country for the LGBTQ population. But we are still far from equality for all. In fact, in a majority of states, today there are no clear, comprehensive protections for LGBTQ individuals in education, in employment, housing, health, and other everyday opportunities and services. Instead, we rely on a patchwork of state laws that leave millions of LGBTQ Americans uncertain about whether their rights and humanity will be recognized in the state where they happen to be living, working, or visiting. In many parts of the country, an LGBTQ worker can get married on a Saturday, post photos of their wedding to social media on Sunday, and be fired on Monday because of who they love, because of who they are. This scenario is a reality for millions of LGBTQ Americans. In fact, 63% of LGBTQ people in this country have experienced discrimination in their everyday lives. Victims include workers, nearly half of whom have been subjected to discrimination in the workplace. They include the nearly 1/4 of all LGBTQ Americans who forego medical care to avoid discrimination in the healthcare system. And they include students and parents and families of LGBTQ individuals like Kimberly Shapley, who will testify today about her struggle to protect her 8-year-old transgender daughter, Kai, from discrimination at school. And we welcome Kai to the hearing today. We cannot ignore stories like Kai's or pretend that they are isolated incidents. We cannot accept the status quo in which an individual's basic civil rights are recognized in one state but then potentially cease to exist when they cross state lines. And we cannot address the widespread discrimination affecting the LGBTQ community, especially transgender people of color, without recognizing and protecting their full identity. We must see people for who they are and for all they are. We must not diminish their humanity or their potential. That is why we are discussing the Equality Act today. This legislation, introduced by Representative David Cicilline and supported by 240 bipartisan members of the House of Representatives, is our opportunity to affirm that this country's landmark civil rights guarantee all people the right to be safe, secure, and free from discrimination. The Equality Act will amend longstanding civil rights laws, including the Civil Rights Act of 1964, to clarify that prohibitions against discrimination on the basis of sex includes gender identity and sexual orientation. Specifically, the bill simply adds the words, sex including sexual orientation and gender identity, as a protected characteristic. Where sex is already included as a protected characteristic, it adds including sexual orientation and gender identity. This language is to explicitly prohibit discrimination in federally assisted programs, and it will make clear that federally supported schools cannot discriminate against students and employees. And it will also make clear that LGBTQ adults and children cannot be denied a medical checkup, counseling, therapy, or other primary care services because of their sexual orientation or gender identity. Today, we may hear excuses about why Congress cannot or should not guarantee protections for LGBTQ Americans. We may hear claims that the Equality Act will endanger religious freedom or put women's rights and safety at risk. But we can look to the 20 states already providing these explicit protections and know that such claims are unfounded. In states like my home state of Oregon, where the Oregon Equality passed in 2008 with my support as a then state legislator, the predictions based on fear have not happened, and in fact, women have experienced expanded rights and protections. We cannot let fear impede progress. The American story is one of expanding equality for marginalized people. Today we're writing an important passage in its latest chapter. I'm going to recognize the ranking member, but I want to, before I do that, echo Judiciary Committee Chairman Jerry Nadler, who convened a hearing on this bill last week. To the LGBTQ and gender nonconforming people who are watching this hearing today, you may be told that you are not welcome. You may hear that your identity is only, quote, temporary confusion, and you may have your humanity questioned. To these individuals, we see you, we affirm you, and we are here to fight alongside you to make sure that all Americans have the freedom to be who we are. With that, I thank the witnesses again for being with us, and I recognize Ranking Member Comer for his opening statement.
Thank you, Madam Chairman, for yielding, and I want to add my welcome to the witnesses for being here today. You have quite a task ahead of you. This is the first hearing this committee, which has a referral on H.R. 5, has scheduled on the bill, and it's being considered a legislative hearing. That means we're supposed to talk about the bill itself. However, we skipped the step of holding a hearing on the underlying issues of the bill. I'm sure there are reasons for that, but that means our members haven't had the opportunity to participate in a hearing focused on information gathering on these issues and how they intersect with American schools and workplaces until now. So you've signed up for a huge task. A bill with a name like the Equality Act sounds like a bill in some way advocates for all people. That's what we strive for in this country. Equality before the law. That's why over the more than 2 centuries this country has existed, we have thankfully updated our laws to right past wrongs and bring us closer to treating all people with the dignity they deserve. But as I look at H.R. 5 and learn more about what's in the bill, I'm deeply troubled, and I believe most Americans would be deeply troubled by what's really there. This bill is following in the tradition of others we have seen so far throughout Congress. A clever name, an allegedly noble purpose, but a vehicle for serious, harmful consequences. It's completely unacceptable that this bill today totally guts the Religious Freedom Restoration Act of 1993, this country's flagship law in defense of individual religious freedom. H.R. 5 professes to protect Americans by prohibiting discrimination based on a, quote, perception or belief, even if inaccurate, unquote. This alters federal non-discrimination law in ways that will have unintended effects we cannot know sitting here today. Furthermore, the bill carries clear mandates for sweeping changes and accommodations that will prove costly, burdensome, and problematic for small businesses and schools. I'm concerned about the future ramifications of codifying ill-defined concepts into our nation's civil rights laws and the harm this could bring to already vulnerable populations. I'm fortunate to represent the people of Central and Western Kentucky, folks who believe in human dignity and fair treatment for their fellow citizens. The poor execution of this bill, I'm afraid, will result in certain persecution for millions of innocent Americans who are still under the impression that religious freedom is a fundamental American right. Equality and freedom must coexist. H.R. 5 totally redefines one and delivers a serious blow to the other. Thank you, Madam Chairman, and I yield back.
Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on April 22nd, 2019. I'm pleased to recognize my colleague and a member of the full Committee on Education and Labor, Congressman Joaquin Castro of Texas, to introduce the first witness.
Thank you, Chairwoman. I'd like to introduce a fellow Texan, Kimberly Shapley. In Texas, we've seen a backlash, especially among some of our politicians, against movements towards equality. But as Kimberly and her daughter Kai show, our state is changing in a positive and amazing direction. Kimberly was propelled into advocacy by her 8-year-old transgender daughter, Kai. With Kimberly's support, Kai socially transitioned at the age of 4. In her position as Faith Outreach Coordinator for Equality Texas, she's worked with and educated universities, Christian congregations, and church leaders. In 2017, Kimberly testified before the Texas State Senate in opposition to SB 3, a bill that would have prohibited transgender individuals from using the restroom that aligns with their gender identity. Her family story has appeared on The Today Show, HBO, The Huffington Post, and Good Housekeeping, among others. And we're very proud to welcome Kimberly here today to testify. Thank you for being here.
Thank you, Mr. Castro, and welcome, Ms. Shapley. And I'll now introduce the remaining 3 witnesses. Patrick Hedren is Vice President for Labor, Legal, and Regulatory Policy at the National Association of Manufacturers. Mr. Hedren leads NAM's advocacy before Congress and the executive branch and previously served as senior counsel for a Fortune 15 manufacturing company. Lawrence Lorber, did I get it right? Is senior counsel at Seyfarth Shaw LLP. He is an experienced employment law practitioner who counsels and represents employers in connection with all aspects of labor and employment law. He was appointed by congressional leadership as one of the 5 original directors of the Office of Compliance charged with implementing the Congressional Accountability Act, applying 11 labor and employment laws to the Congress and congressional entities. Sarah Warbelow serves as legal director for the Human Rights Campaign, HRC, leading the organization's team focused on federal, state, and municipal policy. She also coordinates HRC's advocacy efforts as amicus curiae, or a friend of the court, in litigation affecting the LGBTQ community. She previously served as HRC's state legislative director, working with state and local legislators and LGBTQ advocacy organizations in pursuing their LGBTQ-related legislative priorities. I have a couple of instructions for the witnesses. We appreciate you for being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements. They will appear in full in the hearing record. Pursuant to Committee Rules 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Also, let me remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress, or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so it will turn the microphone on and members can hear you. And as you begin to speak, the light in front of you will turn green. After 4 minutes, it will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask you to please wrap up. We're going to let the entire panel make their presentations before we move to member questions. When answering a question, please again remember to turn your microphone on. I will first recognize Kimberly Shapley.
Good afternoon, Chairwoman Bonamici, Ranking Member Comer, and members of the committee. My name is Kimberly Shapley. I was born and raised in the South. I'm a school nurse, an ordained evangelical minister, and the proud mother of a beautiful transgender 8-year-old girl named Kai. My family and I used to live in Pearland, Texas, an ultra-conservative area that was once a great fit for my strong evangelical faith and Tea Party ideology until we moved 2 years ago. You see, because of my faith and background, I was not always accepting of the fact that my daughter is transgender, nor did my heart and mind change overnight about lesbian, gay, bisexual, and transgender people. It has been a years-long process that only happened because of Kai. Even before the age of 2, Kai's mannerisms were notably feminine. She chose traditionally female roles and toys traditionally for girls. Immediately, I intervened. I requested that the daycare put away the girl toys so Kai couldn't play with them. But by 3 years old, Kai was telling anyone who would listen that she is a girl. That's when I implemented a home remedy version of conversion therapy. I hated it, but I felt responsible to save my child's soul. Things changed for me when I overheard Kai praying for Jesus to take her home to be with him forever. That's when my knowledge of science finally overrode my poor theology. I remembered the data on suicide risk for transgender youth whose gender identity is not supported by their families. So Kai socially transitioned at 4.5. Around that time, President Obama issued guidance for schools to let transgender children use the bathrooms that match their gender identity, a hopeful development. At first, I thought no one had to know that Kai was transgender. I spoke to Kai's school principal about respecting that privacy and allowing her to use the girls' restroom before she started school. But that could not remain a secret in our town, nor was it authentic to who Kai is. Our district superintendent compared transgender people to pedophiles and polygamists in a public statement. The lieutenant governor told district superintendents not to follow the Obama guidance. The result for my daughter was a terrible school environment. Kai was frequently locked out of the only restroom she had access to, leaving her to have accidents in front of her peers. She was frequently reminded of her birth name by staff members and even by teachers. Peers bullied her with little or no intervention from school staff until one day she came home and told me that she couldn't take it anymore. I relocated my family 2 weeks later to Austin, leaving the area that I had known for more than 25 years to save her. To this day, I have friends and family who I do not communicate with because I accept my daughter. When I enrolled her in Austin ISD, we were welcomed by a sign that read, "We are proud to be a safe, supportive, and inclusive campus," and I wept. For the first time in a long time, I felt that she would be safe. Her first day of school, she ran home to write in her diary because she had had the best day ever. She had freely used the appropriate restroom at school. In Austin ISD, parents don't complain, and her classmates invite her for sleepovers. District leadership has set a standard to be kind and truly inclusive, and the staff has made note of Kai's gifted intelligence. Her former school had been too focused on her identity, they never even noticed her IQ. I currently work with Equality Texas as Faith Outreach Coordinator, and I frequently speak in conservative spaces. I consider my philosophy as an activist one of the most important things that I've learned as a nurse. Educate people by meeting them right where they are. Because of this mindset and the mindset that I overcame, I am uniquely qualified to do this. But I won't always be here to protect my daughter. She, trans kids like her, and LGB kids need the Equality Act because they deserve a future where they won't experience discrimination at school, when they apply for a job or rent an apartment. Our country had determined long ago that discrimination is wrong. Choosing to exclude people for how they were born is not an American value. We must do better. I welcome questions and I appreciate dialogue, even if we disagree, and I thank you for inviting me to share our story.
Thank you very much, Ms. Shapley, for your testimony and for participating, and thank you, Kai, for being here today. Next, I recognize Mr. Hedren for 5 minutes for your testimony.
Chair Bonamici, Ranking Member Comer, and members of the subcommittee. It is an honor to testify in front of you today on the workplace provisions in H.R. 5, the Equality Act. My name is Patrick Hedren, and I am the Vice President of Labor, Legal, and Regulatory Policy for the National Association of Manufacturers. The NAM is the nation's largest industrial trade association and the voice for more than 12.8 million men and women who make things in America. We represent more than 14,000 manufacturers, of which upwards of 90% are small or medium-sized. The NAM is committed to achieving a policy agenda that helps manufacturers grow and create jobs. We also believe that equal opportunity is a key pillar of our great democracy, one that allows every individual to pursue the American dream based on his or her own talents and qualifications. Manufacturers and the business community have made great strides already in providing non-discrimination protections for our LGBT employees. There is still further to go, however, and manufacturers believe now is the right time for Congress to act to help our country get there. That is why in March, the NAM joined with now 46 other industry associations representing a stunning breadth of the American economy in support of the Equality Act. In our view, amending the Civil Rights Act of 1964 to include explicit non-discrimination protections based on sexual orientation and gender identity is a smart approach. It is less burdensome from a business or economic perspective than other methods. In fact, we believe a federal standard will help manufacturers better attract and retain a talented workforce, which is greatly needed as we face a major skills gap. According to the NAM's most recent quarterly outlook survey, 71.3% of manufacturers expressed worry about their ability to attract and retain the workforce they will need moving forward. There are nearly 500,000 unfilled jobs in the sector already, and about 2.4 million jobs could go unfilled by 2028. Attracting talented employees is a multifaceted effort, but manufacturers have known for years that an inclusive workplace with meaningful LGBT protections helps them hire and retain the best possible workforce. Manufacturers have been some of the strongest leaders in creating a more welcoming workplace, as outlined in my written testimony. The Equality Act would assist our efforts by helping manufacturers ensure that every employee knows they have a right to feel safe from discrimination, harassment, or worse on the manufacturing floor. Many states and hundreds of localities have already explicitly protected residents from sexual orientation and gender identity-based discrimination in the workplace, all with slightly different requirements and definitions. A uniform federal approach will help business by providing a clear basic level of non-discrimination protection across the states. This consistent approach would give certainty to employees who may wish to move from one facility to another, and it would establish predictable baseline rules for employers, making it more cost-effective to educate employees and enforce these protections. The framework of Title VII brings with it two important pragmatic features: a basic applicability threshold of 15 or more employees, and a religious exemption that allows employers to differentiate between employees based on a bona fide occupational qualification. The 15-employee applicability threshold serves principally to protect smaller firms from the burden of compliance and oversight, or red tape, that applies to larger employers. Businesses with 15 or more employees already must understand and comply with Title VII. This fact is a key benefit of the Equality Act. The BFOQ defense allows religious employers to maintain their religious values and teachings in making hiring decisions for specific positions that require it. By amending Title VII in this manner, the Equality Act would also draw upon current case law regarding sex discrimination. Employers' and employees' rights would not need to be established as issues of first impression through decades of litigation and court opinions. These cases and EEOC enforcement guidance, to an extent, already exist. The Equality Act puts sexual orientation and gender identity on a level playing field with other sex-based non-discrimination protections. In conclusion, manufacturers have been at the forefront in providing their employees with fair and meaningful protections against sexual orientation and gender identity-based discrimination. Partly, this is because talented employees demand it. Partly, this is because employers understand the importance of creating an environment in which the very best people can succeed based on merit. There is, however, also a much broader side to this discussion. Namely, manufacturers believe that discrimination of any kind is antithetical to the values we work to uphold every day: free enterprise, competitiveness, individual liberty, and equal opportunity. These are the four pillars that underpin what makes manufacturing strong. These are the values that help make our country great. They're also the animating rationale behind our support of the legislation. We can do this. Thank you, and I look forward to answering any questions you may have.
Thank you for your testimony, Mr. Hedren. And now they are calling the votes on the House floor. So when we come back after votes, we will hear from Mr. Lorber and Ms. Warbelow, and then we will move into questions. So the committee is temporarily in recess until immediately after votes. Thank you. The Subcommittee on Civil Rights and Human Services hearing on the Equality Act, H.R. 5, will resume, and I appreciate the patience of everyone waiting during the vote series. We are now moving to the testimony of Mr. Lorber, and you are recognized for 5 minutes for your testimony.
Thank you. Chair Bonamici, Ranking Member Comer, members of the subcommittee. My name is Lawrence Lorber, and I am pleased to be able to present this testimony at this most important hearing. As I set forth in greater detail in my testimony, I've had a long career as an employment and labor lawyer, both in government positions, in private practice, and with respect to major legislative actions. I must note that my purpose here today is not to recommend whether this committee or the Congress should ultimately decide to pass H.R. 5, but rather to offer comments on this legislation and to highlight issues which may warrant the attention of this committee. I'm not testifying today on behalf of my law firm, clients, or other affiliations. I begin by noting that H.R. 5 differs significantly from the prior version of the Employee Non-Discrimination Act, ENDA. ENDA dealt primarily with employment issues and had evolved to thoughtfully deal with those issues. H.R. 5, however, deals with a host of issues and existing statutes. H.R. 5 does little other than incorporate sexual orientation and gender identity into the definitional provisions of those statutes without addressing any of the implementation or interpretation issues which should be the subject of some focus. In particular, H.R. 5 merely includes the new protected classes into Title VII with no explanation. While it should be noted that there are probably more statutory provisions impacting employment with different administrative and remedial schemes, this has been caused in part by the fact that each new protected class brought certain issues which had to be specifically addressed. So when Congress passed the Civil Rights Act in 1964, it kept the Equal Pay Act separate. When Congress addressed the issue of age discrimination shortly after the Civil Rights Act was passed, it decided not to include age in Title VII, but created a different statutory framework. The same decision occurred with disability issues when the ADA was not included in Title VII with respect to employment, and when GINA was not included in the ADA. So simply including sexual orientation and gender identity into Title VII without the provisions and protections included in all of the various versions of ENDA will leave employers and members of the protected class unable to understand their obligations or rights. For example, ENDA prohibited the collection of data showing the status of employees or applicants, as does GINA, the ADEA, and the ADA. H.R. 5 has no such protection. And by including the employment provisions of H.R. 5 into Title VII, it is unclear, at least, as to whether the EEO-1 data collection form will have to now include sexual orientation or gender identity. Prior versions of ENDA did not require employers to build new or additional facilities. H.R. 5 is silent as to those obligations. Prior versions of ENDA permitted employers to require reasonable dress and grooming standards as long as they were neutral, and permitted employees to notify their employer that they were undergoing or had undergone gender transition and therefore could assume the identity of their transition gender. H.R. 5 is silent. ENDA prohibited the establishment of preferences granted to individuals because of the individual's sexual orientation or professed gender identity. H.R. 5 is silent. And there should be one other point to emphasize. H.R. 5 seeks to deal with employment by simply amending Title VII. It does not recognize that Title VII does not permit the EEOC to issue regulations. Therefore, these issues will be dealt with in litigation, and the certainty asked for by proponents will not be available. 2, it is suggested that provisions of H.R. 5 will somehow provide a degree of uniformity and consistency in the interpretation of all these obligations. But as we well know, there is no preemption of state or local law by Title VII or indeed the other employment laws, so that H.R. 5 will offer no uniformity or consistency. It will just add another layer of legal obligations to the already towering degree of legal obligations and restrictions in the employment area. I do discuss the issue of the implications of the Religious Freedom Restoration Act and how it will coincide with H.R. 5. It has been stated that RFRA, which was overwhelmingly passed to deal with serious concerns of religious discrimination and which was introduced by leaders of Congress, including Senator Kennedy and then Representative Schumer, perhaps no longer merits consideration or enforcement. While Congress can certainly amend or revoke statutes, it seems strange that it will undermine the implications of one statute for the purpose of another. It certainly should be possible to address the issues raised by the Restoration Act without denigrating its importance. RFRA has not faded from the statute books. I have addressed other issues in my testimony, but remain willing and anxious to answer your questions. Thank you very much.
Thank you for your testimony. We now recognize Ms. Warbelow for 5 minutes for your testimony.
Thank you, Chair Bonamici, Ranking Member Cormer, and members of the committee for welcoming me here today. My name is Sarah Warbelow. I'm the legal director for the Human Rights Campaign, our nation's largest civil rights advocacy organization working towards full equality for the lesbian, gay, bisexual, transgender, and queer community. I'm honored to provide this testimony on behalf of our more than 3 million members and supporters nationwide. In addition to testifying today before you as a legal expert on non-discrimination laws, I do so as a bisexual woman who is a proud parent of a transgender daughter and a sister and sister-in-law to married lesbian mothers who are beloved by their community. A system that relies on a patchwork of law to protect LGBTQ people facilitates unequal treatment across state lines and from city to city. In 28 states, there are no explicit non-discrimination protections on the basis of sexual orientation, and in 29, there are none on the basis of gender identity. While courts and agencies have increasingly interpreted sex non-discrimination laws in our civil rights, discrimination protections in our civil rights laws to include LGBTQ people, enforcing these judicially crafted protections requires legal awareness coupled with the financial or other resources necessary to bring a case, where the question of whether you are even covered by law is often contested. This is a luxury that is far out of reach for the majority of our community. The Equality Act builds upon the legacy of landmark civil rights statutes that have made this country a stronger nation that recognizes diversity as an asset and not a liability. It's essential that these foundational statutes continue to be vigorously enforced by the courts and respected by this body. Congress adopted the 1964 Civil Rights Act in an effort to dismantle the racist, sexist infrastructure that framed the daily lives of people of color and women in this country, recognizing that absent these protections, ordinary people were denied the ability to fully participate in public life. The Equality Act serves an analogous purpose by providing critical protections from discrimination across key areas of life, not only for the LGBTQ community, but also for all women, communities of color, and people of faith. Everyone must have the right to fully participate and contribute to public life. The Equality Act amends existing civil rights laws, including the Civil Rights Act of 1964, the Fair Housing Act, the Equal Credit Opportunity Act, the Jury Selection and Services Act, and several laws regarding employment with the federal government to explicitly include sexual orientation and gender identity as protected characteristics. The legislation also amends the Civil Rights Act of 1964 to prohibit discrimination in public accommodations and federally funded programs on the basis of sex, including sexual orientation and gender identity. Additionally, the Equality Act modernizes Title II of the Civil Rights Act to provide protections comparable to those under many state laws and the Americans with Disabilities Act, which would strengthen protections for everyone and more accurately reflect the services we rely upon and the places we move through in the 21st century. The Equality Act reflects the development of sex discrimination jurisprudence to protect LGBTQ people. Following the Supreme Court's decision in Price Waterhouse versus Hopkins, courts and the federal government have extended the theory of sex stereotyping to develop a clear legal trajectory affirming these protections for LGBTQ people. These judicial advances provide LGBTQ plaintiffs with meaningful legal recourse. However, they have not provided the broad and clear, uniform, explicit federal statutory protections would bring. The Equality Act would equip individuals with more knowledge of their rights to be free from discrimination and ensure that business owners, employers, landlords, and other covered entities are aware of their obligations under law. Incorporating these protections within the U.S. Code would make it possible for individuals and businesses to know their rights by reading a sign posted in the break room instead of heading to the courtroom. Now is the time to pass the Equality Act. LGBTQ people live in every state and virtually every county coast to coast. We are your neighbors, co-workers, friends, and family. We are a part of the diverse and dynamic fabric of our country. No one should be subjected to discrimination based on who they are, whether at work, in school, seeking emergency services, or picking up the groceries. At its core, the Equality Act would deliver on the promise of equal opportunity for all.
Thank you for your testimony. Thank all the witnesses for your testimony. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. Before we begin, without objection, I would like to enter into the record letters of support for the Equality Act from the U.S. Chamber of Commerce, the ACLU, and the Alaska Air Group. Without objection. I now recognize myself for 5 minutes. Ms. Shapley, thank you so much for being here today to testify about your experience as the mother of a transgender daughter. You exemplify bravery and humanity, not only by taking control of Kai's education and moving your life to a community that would be welcoming for her, but also by devoting your time to advocating for protections for other transgender kids and their families. I have met with families in Oregon. I remember Ella and her family, and I know many of them went through similar challenges to find safety for their kids. So you talked about the inclusive environment in Kai's school in Austin. Can you tell us a little bit about how Kai has been affected by this new school and what changes you've seen in her since she transferred?
I think the biggest thing about being in an inclusive school district is that Kai's just a kid now. We're not focused on other things. You know, her first day of school, she ran upstairs to write in her diary about using the restroom at school. How sad is that? In Austin, they have signs at every campus saying that we are an inclusive, safe school. For a mom like me, that brought healing, just knowing that we weren't going to have to go through this same thing. We were so focused on bathrooms and her name and the struggle and the things that the superintendent was saying and doing and the way we were being treated that we weren't focused on her education. Moving to an inclusive school district allowed my daughter to realize how smart she is and that she loves math and that she loves science. And we get to do normal things like normal girl fights between her and her peers that have nothing to do with the way that she was born.
When you think about other kids whose families can't move them to a school like the school in Austin where Kai attends now, how would the Equality Act, what would that mean to them?
It would allow their children to have a fair opportunity for an education. Because I promise you, we weren't getting the same educational level when they were focused on the bathroom, when they were focused on her being transgender. She wasn't getting the education that she was entitled to. And everything about Kai changed. Everything about our family dynamic changed. That extra stress, you know, kids, especially trans kids in schools, they're at higher risk for mental health issues and depression and anxiety. And it's not because they're transgender, it's because the way they're being treated because they're transgender.
Right, and I know a lot of the homeless youth are LGBTQ, so thank you again. Mr. Hedren, thank you for your testimony today. You talk about how in 2016 the NAM Board of Directors voted unanimously to affirm the support of manufacturers for equal treatment in personnel matters without regard to sexual orientation or gender identity, and I applaud you for that important step. And on this committee, we've long supported our manufacturing workforce. And I appreciate in your testimony how you talk about how this bill will bolster the manufacturing sector. So some states have already passed legislation protecting LGBTQ employees. Have you seen a difference in the hiring and competitiveness for your member businesses operating in those states? And then you mentioned in your testimony also something about if someone gets a promotion, for a company that's in several different states, how would it affect them if they were moving from a state like Oregon with protections to a state without? How would that affect them? How would it affect the workforce?
Chair Bonamici, thank you for that question, or both of those questions. I think what you're hitting on here is a really, really important element of where we are as a sector right now. And this is true sort of broadly speaking, but we're all about workforce. We need to attract people into the sector, and there are some misperceptions that sort of persist about what our sector really looks like. So for example, people have an image in their head of these sort of dark, dangerous, dirty factories, and nothing could be further from the truth. We need to attract a workforce that reflects that change in who we are toward a sector full of innovative and world-changing ideas and execution. The question about the regionality and the application of that, I think, is going to be a little bit different for each company, but I look at a few examples on how this has affected companies with whom we work. And in fact, I have a handful of letters which I would love to submit into the record on their behalf. But I'll pull on a couple examples in particular. So for example, General Mills has noticed that for talented employees who are offered positions in areas that may lack these protections, it may cause them to think twice about taking that opportunity. And in a company like General Mills, being able to take these rotational opportunities to broaden your experience is critical to your growth as a leader.
Thank you. And I need to set a good example, and I've already gone over time. So please, if you will submit the rest with your testimony, that would be appreciated. I yield back, and I recognize Mr. Comer for 5 minutes for your questions.
Thank you, Madam Chair. And I'm going to address my questions to Mr. Lorber. Mr. Lorber, the public accommodations provision in the Civil Rights Act applies to places like hotels, restaurants, theaters, and stadiums. H.R. 5 would greatly expand the definition of a public accommodation to include an establishment that provides a gathering and any establishment that provides a good, service, or program. Now, in your view, does the definition of public accommodation in H.R. 5 have any limits?
No, Congressman Comer. As drafted, H.R. 5 does not put limits on definitions of public accommodations. Under, for example, Title II of the Civil Rights Act of 1964, which covers public accommodations are defined as hotels, restaurants, and places of entertainment. Section 3 of the Equality Act expands that, as you said, to places of gathering and any establishment that provides a good service or program. And I would focus on gathering and program to indicate it could cover, indeed, religious facilities.
Could this even apply to a church?
Yes.
Or other place of worship? Yes.
Sure, because they do conduct various activities which are church-related but are public gatherings.
H.R. 5 requires businesses and nonprofit organizations to provide access to facilities such as restrooms and locker rooms in accord with an individual's gender identity. Could you discuss the challenges that businesses, other organizations, and individuals would face in complying with this aspect of H.R. 5 and what the implications would be if organizations and individuals were not in compliance with H.R. 5?
Sure. I think, as I stated in my testimony, gender identity is defined by actions and not innate characteristics. While access to shared facilities, particularly locker rooms, is obviously an open question, it seems that with respect to locker rooms in particular, access should require more than a mere self-identification, which cannot be verified and might change. Employers certainly want to follow the law, but they also have obligations to their employees. Gender identity differs, for example, from the transgender community in this regard, and employers would be subject to all of the damages and other remedial provisions set forth in H.R. 5.
So, under this bill, would a school have any choice other than to allow a biological man to participate in women's sports if the man identifies as a woman?
Well, as I don't think it would be appropriate to have a male participate in women's sports. As I noted in my testimony, there is significant precedent under Title IX addressing gender equality. Title IX, its regulations at 34 CFR 106B, would seem to suggest that the situation raised in this question would not occur. Ms. Warbelow's testimony seems to suggest this situation only arises when the individual is a transgender, but she ends by simply stating that the added protected classifications ensure that all students have equal access to the field. She cites the Videcus case, but that case only dealt with lesbian participants in a women's basketball team.
So would a college or university, a public college or university, have to award him, if he were on a women's basketball team, I'm using basketball as an example, or any sport, a scholarship that would otherwise go to a woman if he fit the criteria for the award?
Yes,
under
very
HR
well
5.
Very well might, and I'd add it's not only a public school, but private schools do receive federal grants. So
That's right,
it's
through
not only
the lunch program, right.
public institution, and yes, they very well might be. The way the bill is drafted, it's so broad that it wouldn't exclude that.
So would schools have any recourse to protect the rights of women to have access to these opportunities?
Well, they
HR5?
should, but the problem, again, with this bill is we're sort of overlapping on various rights. Title IX was passed specifically to afford women the rights to participate in all activities, including sports. We now have this bill, which by its terms would seem to change that and at least bring into question the rights of women, if not negate them.
Well, these are some of the concerns that I mentioned in my opening statement, and I'm sure we'll have further questions. I yield back, Madam Chair.
Thank you, Mr. Ranking Member. I now recognize the chairman of the full committee for 5 minutes for your testimony, or excuse me, for your questions, Mr. Scott from Virginia. Chair Scott.
Thank you. Thank you. Mr. Hedren, can you say a little bit more about the business case for the passage of these laws? What happens, how attractive or unattractive is a state trying to recruit businesses based on the laws of the state in this area?
Well, Mr. Chairman, thank you for that question. I think suffice it to say, our members have been remarkably clear with us, with me and my team, that this is of huge importance to them. So one other example that I can raise is that of Dow, which finds that this is a differentiator for them in attracting talent around the country because they're not really located, for the most part, in urban areas or in states that already provide protections like this, including, as I understand it, in their home state. But because they do provide protections like this, they're able to attract employees that are talented and in areas where they otherwise might lack protections in the broader community, but get them inside the fence line, so to speak. So this is, it is a big deal, and in fact, they've found that not only is there a case to make in terms of talent and protecting employees and equality and non-discrimination, but there's also a business case to be made for it. So they identified that their costs of implementing unilaterally protections for these employees have gone down on the whole because attracting and retaining talented employees is expensive in itself.
Thank you. Ms. Warbelow, we heard a suggestion that laws like this are costly and unworkable. Although most states don't have protections, many do. What has been the experience in terms of costliness and workability of these kinds of laws?
Yes, thank you for that question. States across this country and hundreds of municipalities have adopted non-discrimination protections that include sexual orientation and gender identity. When we look at the data, we find that rates of complaints for sexual orientation and gender identity are about on par when you compare per percentage of the population to complaints based on sex or based on race. What this demonstrates is that laws like the Equality Act are critically needed, but that they don't place a huge burden on businesses. In fact, the vast majority of the Fortune 500 companies are already providing some level of protection to their employees. But what they want to make sure of is that their employees have those full protections outside of the four walls that they control. So when their employees are attending night programs for schooling, when they are purchasing a house or looking for an apartment, or when they're going out to dinner with their families.
Thank you. Can you say a word about the religious exemption and whether or not it can be used as a defense under the Equality Act?
Yeah. So there are existing statutory protections within the civil rights laws remain in place. Religious employers are able to continue to limit or prefer employees of their own religion. There are exemptions in the Fair Housing Act that remain in place. What the Equality Act does is it limits the application of the Religious Freedom Restoration Act with respect to this set of non-discrimination laws. And when Congress passed the Religious Freedom Restoration Act, it clearly contemplated that this would be necessary at some point in the future. In fact, it statutorily provides for an exemption in future laws. This does not eliminate the Religious Freedom Restoration Act. The Religious Freedom Restoration Act will continue to exist and will be available in instances in which the federal government is itself discriminating against individuals. For example, in 2014, a Sikh employee of the federal government was prohibited from carrying an article of her faith into federal buildings so that she could go to work. She successfully used RFRA to change the federal government's policies and practices. RFRA will continue to be available in circumstances like these.
Thank you. Madam Chair, I ask unanimous consent that to enter into the record documents from the National Women's Law Center and Congressional Research Service that detail the history of the Civil Rights Act of 1964 and the interaction of several of the titles, especially Titles 6, 7, and 9.
Without objection.
Thank you. I yield back.
Thank you. Without objection, I'd also like to enter into the record letters of support from women's rights and gender justice organizations in support of full and equal access to participation in athletics for transgender people, and also letters from the Business Coalition for the Equality Act that lists many employers and associations across the country in support of the Equality Act. Without objection. And I now recognize Ranking Member Fox from North Carolina for 5 minutes for your questions.
Thank you, Madam Chairman. I want to thank our witnesses for being here today. Mr. Lorber, you state in your written testimony that the definition of gender identity in H.R. 5 is not clear. Do you anticipate that H.R. 5's definition of gender identity will create uncertainty or even more dire consequences for organizations and individuals subject to the bill's requirements? Can you expand on the problems that are created when Congress enacts a new legal requirement but does not clearly define what that requirement entails?
Thank you, Congressman Fox. As my testimony explains, the definition of gender identity does not provide any definitive definition. As noted in my testimony and Ms. Warbelaw's, the Hopkins decision did interpret Title VII to prohibit discrimination based on mannerisms or sex stereotypes. The definition of gender identity, including appearance or other related gender-related characteristics, either simply replicates the Hopkins decision or goes further than mannerisms and related appearance. Thus, there will be obligations placed on employers in Section 7, grantees in Section 3 and 6, and places of accommodation in which the coverage will be extremely amorphous. We have seen this situation where definitions are not well crafted, where the Congress had to amend the ADA 20 years after initial passage because it believed that the Supreme Court misapplied the definitions of disability. So the definition of gender identity, or the lack of a definition, could well lead to years of unnecessary litigation and uncertainty for employers and individuals.
Thank you. Mr. Lorber, supporters of H.R. 5 say the legislation will not infringe on religious liberty. Can you explain to the subcommittee what the legal effect is of the provision in H.R. 5 stating that the Religious Freedom Restoration Act of 1993, RFRA, shall not provide a claim or a defense to claims under provisions of the Civil Rights Act amended by H.R. 5. Does this provision eliminate the ability of organizations and individuals to assert their rights under RFRA in the countless matters covered by H.R. 5?
Thank you, Congresswoman. The Religious Freedom Restoration Act was enacted to ensure that there would be no governmental imposition on religious observance and practice. It is and was a civil rights act and is still a federal law. H.R. 5 creates an anomalous situation whereby it states that one federal law involving civil rights addressing sexual orientation and gender identity overwhelms and overrides another federal civil rights law addressing religion. I would note that the findings in RFRA state, quote, laws neutral towards religion may burden religion exercise as surely as laws intended to interfere with religious exercises. So that by summarily negating RFRA, H.R. 5 would seem to negate the protections that RFRA was enacted to protect. Federal statute must be read and interpreted to preserve their purpose. H.R. 5 seems to supplement one statute with another. It would seem, therefore, that Section 1107, the claims, misapprehends the purpose of RFRA and should be reconsidered and, frankly, deleted as inappropriate in the context of a civil rights law.
Thank you, Mr. Lorber. One more question. H.R. 5 expands federal discrimination law to prohibit actions based on a perception, even if inaccurate, that an individual is of a certain race, color, religion, sex, national origin, sexual orientation, or gender identity. Do you have concerns with how this provision would be interpreted and enforced, and whether there would be difficulties with compliance?
Well, yes. In one respect, the provision seems to adopt in part the standard in the ADA that acting on an assumption of a disability, whether a disability is in effect or not, violates the ADA if the underlying action would violate the law. Under Title VII, it's already clear from the Hopkins decision that negative inferences cannot be drawn from mannerisms. If, however, gender identity remains as ill-defined as it is, with no specifications, then employers or managers of public accommodations, for example, may find it extremely difficult to establish policies to deal with the requirements of H.R. 5. Perception is a difficult standard under the law, since it establishes a liability, frankly, on a non-fact. The question is highlighted when the underlying protection is so ill-defined. So the question of perception discrimination, particularly with H.R. 5 as it defines its various new covered classes, will remain and become, I think, a substantial imposition on employers simply to know what they have to do.
Thank you very much, Madam Chairman. I yield back.
Thank you, Dr. Fox. I now recognize Representative Hayes from Connecticut for 5 minutes for your questions.
Thank you, Madam Chair. I also want to thank the witnesses who are here today before this committee for your testimony. I'm a career educator who just came to Congress, and I've always held one very central value, that every child, no matter their background, their identity, their community, their diversity, matters. And I hear a lot about employers and people who abuse policies and how are we going to enforce policy. I want to hear more about the people, because these kids matter. Ms. Shapley, you should not have to advocate for the right for your child to be treated equally in the classroom. That should be a given, and we should do our job to make sure that that happens. And you should not have to move your child to a new school district for fear of their safety and their ability to learn. I'm sorry that that happened to you and your daughter. You should not have to figure out how to advocate for your child. That's our job, too. Our educational system should be built in such a way that all students of all ages know that they'll be treated with dignity and respect and will be safe in school. As I was preparing for this hearing, I made a phone call to our Connecticut kid governor, a 10-year-old girl. Her name is Ella Briggs, and her entire platform was safe spaces for LGBTQ youth. And 6,000 kids in the state of Connecticut voted for her to become our kid governor. And she has advocated fiercely for her community because she recognized and she understood that while she had parents who were supportive and empowering and loved her unconditionally, not every child has that. And she felt bad for them. And this 10-year-old recognized that we have to do something, that the adults have to do something. Her inauguration was one of the very first events that I attended as the Congresswoman from Connecticut's 5th District. And I promised Ella that I would bring her voice and her concerns to Washington. So I'm very happy, Madam Chair, that we're having this hearing, and for you all for coming and sharing your testimony, because Ella can't be here. These kids can't speak for themselves, so they need for us to stand up and speak for them. Ms. Shapley, I mean, we know the statistics. 30% of kids are missing either classes or full days of school because they don't feel welcome, they don't feel safe, that most of our homeless youth population is comprised of children that come from the LGBTQ community. I've seen kids transition out, being kicked out of their homes, and end up not graduating high school or having any opportunity for success in the future. And I'll tell you, whether it's LGBTQ community, whether it's religious freedoms, whether it's ethnic backgrounds, I always operate it with one question in mind. Is this the education I would want for my child? And I challenge everyone to ask themselves that same question. Would this be acceptable for your child? Ms. Shapley, you talked a little bit about having to go to the school and advocate. Can you help us understand a little bit better? Because the kids get it. The adults are the ones that need an education on how to respond. Ella's platform includes teaching teachers how to respond. Can you help us understand how you advocated for Kai to the adults in her community?
Thank you. I think for the adults in the community that want to advocate for Kai or for all kids is to educate themselves. The HRC, the ACLU, Equality Texas, there are resources out there to give you the information so that you have a good knowledge of what the statistics really are. It's approximately 41% of transgender youth will attempt suicide, right? Yeah. That's not acceptable. We need communities. My daughter needs communities to stand up. We need allies. Go to the schools, go to the school board meeting, speak up. Shut down homophobic rants. If your pastor at your church isn't affirming to the LGBTQ community, have a meeting with them and discuss why that might be, and maybe even consider whether your tithe should go to a different church that's affirming of LGBTQ kids, because I think that we're missing the whole point of the gospel when we sit in places that are not teaching love.
Thank you. I appreciate that. I also know that many adults, their biases move forward with them. I've seen higher rates of discipline amongst students who identify as LGBTQ because the adults don't know how to respond. And it's very interesting that you brought up religion, because I was thinking about that. When we're talking about gender identity as a choice and as not innate, and it can be changed at any time, we would never question someone's religious beliefs, which is also a choice and not innate and can be changed at any time. So I just think we have to look at this differently and educate ourselves, because we can't, these kids are relying on us to get it right. Thank you.
Thank you, Representative Hayes. I now recognize Dr. Schreier for 5 minutes for your questions.
Thank you, Madam Chair. Thank you first to all of the witnesses. And Ms. Shapley, thank you for sharing your story. I found it particularly touching and so moving. And Kai is so lucky to have you as her mom. You are her best advocate and such a supporter, and you listened and you heard and you learned and you did the right thing, and unfortunately it required you to go leaps and bounds beyond where you would have to. And unfortunately, not all parents are so supportive, and that's really what troubles me. I'm a pediatrician, and so I see these kids as they grow up, and I know that many parents are not as supportive as you are, and this is one of the reasons that so many transgender teens become homeless teens. So I wanted to tell you about one, and part of this is, you know the story, but part of it is for my colleagues so that they understand what kids go through. So this is one of my patients, and for the sake of confidentiality, because I can't use names, we're going to call him Sam. And he comes from a family probably a lot like yours, a very religious family, a very loving family. But he knew that he could not talk with them about who he was and how he felt and that he was in the wrong body. And so he came to me because I was the only safe person for him to talk to. And I was in the medical office, and I shuddered to think about all these kids who don't have a safe place, even in the doctor's office. He would come in for little things. I mean, practically a broken fingernail, just so he would have somebody safe to talk with, because he couldn't talk to a teacher, couldn't talk to his parents. He came in, I tried to help by saying, hey, I'll sit in the room with you, we could have this conversation together. But he knew that if that happened, he would be kicked out of the house. And so we planned together, and I got him through a few years until he went off to the University of Washington, where he could explain to his parents who he is, feel safe in his own skin and his environment, and finally, at age 18, be okay. So one of my frustrations that I think you share is just this failure of imagination and this failure to be able to be empathetic in our country. We don't support stem cell research until our own kid has a disease that could be helped from it. We don't support marriage equality until our own child wants to get married to the person they love. And so I'm so impressed that you are involved in, and I have to refresh the Faith Outreach Coordinator for Equality Texas, because I think that is the way to change hearts and minds. I wanted to see if you could talk a little bit about your experience there and about how it's going. How are you getting through to people and changing hearts and minds?
Thank you. It started out that I just needed Equality Texas because I went to them when I needed help for my daughter to be able to use the restroom. And I don't even know how it happened that, I'm just on the team, right? Because I needed them. I still need them. And I mean, who takes on somebody with a ministry background and says, hey, you want to work for this LGBTQ group? Why not? So I literally had to move from being a homophobic person into advocating for the community that I used to be so afraid of. And I think that just by telling our story, Kai and I just tell our story over and over and over, and we just get blessed. Doors keep opening for us to share in the most unlikely of places. We speak at affirming churches. We speak at non-affirming churches. We speak at many Baptist churches, Methodist churches. We speak privately with pastors of mega churches. We speak publicly with them. And we just continue to tell our story because we believe that there's power in testimony, and we stay true to our faith. And I believe that that's all we can do, and we just continue to have faith that it'll be effective.
Thank you, and thank you for doing that hard and really important work. I also just wanted to make a couple comments for the record. First is that I know that when we are talking about bathrooms and bathroom safety, that the only person at risk right now is my patient, Sam, that he's the one who is subject to being injured. And I just want to say that it is maddeningly frustrating to hear all of this discussion about the bathroom. I would say similarly about sports. Nobody chooses this so that they can win a race or they can be a football star, that we need to look out for these kids and young adults and make sure that they are welcome. So thank you, and I'm out of time.
Thank you, Dr. Schreier. I now recognize Representative Lee from Nevada for 5 minutes for your questions.
Great. Thank you all for being here and talking about this important act. I wanted to first ask you, Mr. Hedron, you stated that manufacturers believe that discrimination of any kind sharply contrasts with the 4 values of free enterprise, competitiveness, individual liberty, and equal opportunity, and that these 4 pillars underpin what makes manufacturing strong. Can you expand on how the Equality Act will help further these values?
Thank you, Representative Lee, for that question. And in fact, I'd like to make a quick point. So in 2016, when the NAM officially adopted a policy position making clear our opposition to discrimination on the grounds of sexual orientation or gender identity, which, by the way, was a longer running and longer held belief, just recently this spring, the NAM Board of Directors adopted the 4 pillars explicitly as part of the policies that we advocate for. And that was a big moment for us. And it's for reasons just like this. These are important because these are about our workforce, these are about our perception in the community, this is about talent, this is about doing the right thing in the market, and we're frankly in a place that I think has surprised some people. Our members have gone farther, faster than I think many people expected. Is that perfection? No. There's always more to go. But I look at examples of companies like Cargill that have had explicit protections and a perfect record on the Corporate Equality Index for 15 years running. Cargill's a company that's located all over the world with thousands of facilities globally. And they find value in affirming these values for their workforce, for their customers, and for their broader communities. So these are very, very important protections to those who adopt them. I'd also actually like to take the opportunity to mention Salesforce, a company we're not as often associated with, which, like many larger companies, manages a corporate program like an affinity group, which is a company-sanctioned group for folks of particular characteristics to come together and have a place to talk and network and address the issues of the day. And in their LGBT affinity group, they have found that many people join not because of themselves and their own orientation or identity, but because of their families, because of their children, because of their communities. I hope that's a...
No, that's great. Thank you very much. Yeah, I just wanted to follow up. I'm really proud of two major employers in Las Vegas, Nevada, Caesars Entertainment and MGM Resorts support this legislation, are part of the Business Coalition for the Equality Act that we're discussing today. How do you think these values might extend to businesses beyond manufacturing?
Thank you for that question, Representative. I think to a certain extent I need to be a little cautious about describing issues that go beyond our industry, because really what I can talk to is what manufacturers are living now and dealing with in their own workforces. So I do hesitate to go extend into other industries too far. I think that when you look at the list of companies that have come out, for example, as part of the Human Rights Campaign's collection of now over 180 companies, I understand, looking at my co-panelist, she's nodding. That obviously extends well beyond our sector, and I think gives you an example of companies like Caesars and MGM that would not be our members, although perhaps we make the chips, but that also have found it valuable for their own reasons to come out in favor of protections like these.
Thank you. Yeah, I'm really proud of my state that we champion inclusion across the board, whether it's employment practices, educational attainment, or health care for transgender individuals. And can you tell us how discrimination against LGBTQ individuals in public accommodations, including access to health care, impacts business?
Thank you for that question as well. As I mentioned before, with one particular example from Dow, the value of these protections extends beyond the fence line. So in facilities, and in some cases in facilities, this is maybe the only place in a community where employees may feel protected and welcome. The value of these protections obviously extends beyond that. And again, to a certain extent, I'm not actually able to talk about some of the issues that other industries might face here, but suffice it to say that being able to feel safe in your community and like your children can go to school and be treated with love, kindness, and fairness is important to employees no matter what.
Great, thank you, I yield.
Thank you, and I now recognize Representative Trone from Maryland for 5 minutes for your questions.
Thank you, Madam. Before I ran for Congress, I ran a successful business with over 7,000 employees, and for more than a decade, before same-sex marriage became legal in this country, we offered partner benefits for health insurance to all of our team members. I say that not because I'm looking for a pat on the back. You don't get a pat on the back for doing what's right. I say it because we built an inclusive workplace. I know it can be done. I know it's time to ensure every American is protected from discrimination at work. Mr. Lorber, I understand the purpose of your testimony today is not to recommend whether or not Congress should pass the Equality Act. Without endorsing any specific legislation and drawing on your vast experience in the private practice and in government on employment issues, do you feel LGBTQ individuals deserve to be protected against discrimination in the workplace? Would you expand on that?
Sure. I think LGBTQ individuals should be protected, and indeed, 3 courts of appeals in employment have already held that they are protected under the law, so that the issue, in my view, is not protection, though that's critically important, and there should be protection for LGBTQ individuals. The real question is passing this encompassing statute, which amends a variety of other statutes without definition and without guidance, seems to me is just simply an invitation to unnecessary litigation. It's an invitation to unnecessary confusion. As I said in my testimony, there was previous legislation, the Employee Non-Discrimination Act, which over time evolved into a fairly definitive set of guidance, rules, if you will, as to what it meant. What we're talking about here is a quite different beast, if I could use that term, where we're simply throwing out protections without definition. We're dealing, in the case of RFRA, with another statute, and we're in the anomalous position of simply saying it doesn't matter and it doesn't apply except when it does. And that, to my mind, is just not an appropriate way of dealing with these issues. But just to conclude, and I apologize for taking this time, absolutely LGBTQ folks should be protected in school and in the workplace.
Well, at least we've agreed on that point. Thank you.
Yeah, we never disagreed. It's just how it's to be done, and is it to be done in a statutory manner, which simply doesn't make, in my view, for the return, a lot of sense.
Mr. Hedren, the National Association of Manufacturers recently joined a letter with 40 associations in support of workplace non-discrimination protections contained in the bill. Madam Chairwoman, I'd like to submit that letter for the record.
Without objection.
Thank you. Mr. Hedren, from my understanding, this level of support is new. Why do you believe all these groups have come together now to call on Congress to support the Equality Act?
Thank you, Representative Trone, and thank you for entering the letter into the record as well. I know that's important to us and to others who signed on to it. Why now is a really, really good question, and I think the answer is a little bit to play off of my co-panelist and talk a little bit about what has been going on in the trajectory of cases in the federal courts. The state of affairs for protections for LGBTQ individuals is a little bit confused, and it depends a little bit on where you sit, actually more than a little bit. And because of that, I think employees and employers are at times unclear what their obligations are under the law and what will apply to them. So I would actually disagree respectfully with my co-panelist and say the value of statutory clarity is that it puts on notice both employers and employees as to what rights look like and more or less how they work. Now, I will also say that I do share my co-panelist concerns with the thought of litigation that could run for years to explain these issues further, and I would posit that this type of litigation isn't necessarily a good thing for employers or for employees. But I do think that that's the opportunity that we have now, is to work through these questions where reasonable lawyers may disagree and to find the right way to get them done. And for that reason, I'm grateful for the chance to work with the committee and other members of Congress to do that this term.
Thank you. Yield the balance of my time.
Thank you, Representative. And I am now going to move to the members of the full committee who are not members of the subcommittee. We're glad they're here today. And I recognize Representative Takano from California for 5 minutes for your questions.
I thank Chairwoman Bonamici for this important hearing. And as co-chair of the LGBT Equality Caucus and as a former teacher, I want to ensure that schools are welcoming places for all students regardless of their gender identity or sexual orientation. And I want to make sure that workers and workplaces are protected from discrimination. I want to make sure that people, LGBT people who are want to buy something at a store or go to a hotel, or do business with anybody who's in the marketplace, that they are, that they are covered under the public accommodations portion of this law. All Americans, and especially children, deserve equal protection under the law. No person, no matter where they live in this country, should face discrimination. Equality should not depend on the zip code where you live. All students should be allowed to receive an education without fear of discrimination, which is why I'm proud to be a co-sponsor of the Equality Act. California, along with 14 other states and the District of Columbia, have laws prohibiting discrimination against students in public education on the basis of sexual orientation and gender identity. With 2 states prohibiting discrimination on the basis of sexual orientation, it is beyond time that we have a federal law ensuring protections for the most vulnerable in our communities, no matter where they live. When students attend schools, they should receive a good education, not bullying or mistreatment because of who they are. Ms. Shapley, I too was really moved by your testimony and just the journey you have traveled as a mother. But I know you're a school nurse, and I assume you've seen your fair share of students who've come to you attempting to get out of school. Can you tell me more about that?
Yes, and I am a middle school nurse, and we do have LGBTQ kids in the schools that need extra love, yes.
Extra love. I don't know why that kind of hit me emotionally, but you did. I was a middle school teacher at one point too, and I remember having a transgender. Back 20, 25 years ago, I even as a gay person, I didn't quite understand transgender myself then. But I knew this student was being bullied and didn't have the tools as a teacher. Administrators didn't have tools to deal with the bullying. And there really was not a law that this young person could use to seek protection. We know that many students are facing some sort of bullying, and would you also say, Ms. Shapley, it's kind of fair to say that it's sometimes true that educators don't want to know that there's bullying or that it's hard to know that it's going on?
Yes, I would say that is true.
What are some of the social and emotional consequences of discrimination for gender identity and sexual orientation in schools?
Well, in a bigger picture, I guess, is the way that I can answer that.
Yes.
Okay? So we have these kids who have peers that are bullying them. There are teachers who decide that they don't want to intervene because maybe they agree with the kids that are bullying these kids. Mm-hmm. That was the case for us. I mean, my child was bullied by her peers, but there were staff members who chose to look the other way. And I believe that the staff members who were consistently calling her by the wrong name were bullying her as well. They knew that this was hurting her, but yet they consistently did it, and that to me is bullying. Like I said earlier, transgender kids specifically, but LGBTQ kids, they're at higher risk for mental health issues and for physical health issues, and it's not because they're transgender, it's because of the way they're treated.
It's sad to know that there are adult teachers who don't understand and would passive-aggressively, intentionally call a student by a name that student doesn't want to be called by because of their beliefs.
Correct.
It's a disrespect to that student. My time is running out. I wish we could talk a lot more about bringing this story more to light, but I appreciate your being here today. And I want to just urge all my colleagues in the Congress to pass the Equality Act. Time is long overdue, and I yield back.
Thank you, Representative. I now recognize Representative Davis, the chair of the Higher Education Subcommittee, for 5 minutes for your questions.
Thank you, Madam Chair. Ms. Warble, I wanted to ask you, thank you all for being with us today. We appreciate it. Federal law currently prohibits juror discrimination on the basis of race, color, religion, sex, national origin, and economic status. But as I think you well know, there are no clear protections for those in the LGBT community. Why is it important to amend the Jury Service and Selections Act to include LGBTQ people?
Thank you for that question. You know, discrimination on jury service undermines our democracy, and it's a serious problem. There was a case in which a gay man was stricken from a jury based on his sexual orientation because the attorneys believed that he could not be unbiased in contemplating a case involving HIV medications. This was not only damaging to him as a member of our society, but also damaging to the process, ensuring that all Americans have an opportunity to have a jury of their peers, and that all instances and issues that crop up in daily life are fairly considered by a cross-section of the American population. And that's one of the reasons that the Equality Act amends this critical area of law.
And have you seen clear evidence that that happens, that there really is not that opportunity to make sure that actually it is a fair hearing?
Yeah, you know, it's very much jurisdiction by jurisdiction, and it's a very small number of states that have tackled this issue. We really need to make sure that it is nationwide for all of our federal courts.
Thank you. We've been working on it for some time, so I appreciate that. Ms. Shapley, I want to thank you also for your very frank, honest testimony. My colleague, Mr. Takano, just asked you a question about the schools. We see that it made a really big difference for Kai when she found a safe and healthy environment. What do you think schools across the country need to do far better then? You just spoke about the staff involvement, of teacher involvement, and sometimes it ends up being more negative. What do they need to do better and really focus in?
I think that there needs to be some continuing education for teachers and staff. For some of these teachers that have been around for a while, perhaps they haven't been educated on LGBTQ issues. I think that that would be a great place to start, is just by educating. I think that we have to look at leadership. We have to look at leadership, superintendents and principals. Your teachers are going to follow what their leaders set as an example and the tone for the school. And I think that that's a great place to start, is just to try to get people to understand that discrimination is wrong and that they're hurting these children. People go into education because they love children and they want to do good things for children. And I think that if we arm them with the education that they need, they would make good choices for these children.
Thank you. It's a good message. Whatever setting you're in, it starts at the top. Thank you. Appreciate your being here.
Thank you, Representative Davis. Before we move to closing, I would, without objection, like to enter into the record letters of support for the Equality Act from the American Association of University Women, a letter or a map showing from the Human Rights Campaign the states that have addressed discrimination and, importantly, the states that have not, a letter from the National Women's Law Center, and a letter from the National Center for Transgender Equality. Without objection. I remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the committee or invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame, but please recognize that years from now that link may no longer work. That's my favorite part of this. So again, I want to thank the witnesses for your participation today. What we've heard is very valuable. Members of the committee may have additional questions for you. We ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days to receive those responses. And I remind my colleagues that Pursuant to committee practice, witness questions for the hearing record must be submitted to the majority staff or committee clerk within 7 days. The question submitted must address the subject matter of the hearing. I now recognize the distinguished ranking member, Mr. Comer, for his closing statement.
Thank you, Madam Chair, for yielding, and it's very clear this is a difficult subject, and I appreciate you all coming to testify here today. What is clear is that this bill is not ready to become law, and Mr. Lorber discussed several significant concerns with the scope and application of the language in H.R. 5. Specifically, our concern with what it does to the Religious Freedom Restoration Act, unfunded mandate in public schools, as well as the disarray it could potentially create in women's high school sports. And to that point, I have several letters and documents I want to include in the record, which I'll highlight several concerns with the bill. First letter is in opposition from the Council for Christian Colleges and Universities, letter from 7 medical professional organizations expressing their concern, letter from Women's Liberation Front, letter from the American Association of Christian Schools noting the harm the Equality Act would cause to Christian education in America, ACSI, Association of Christian Schools International, expressing concerns with respect to the Religious Freedom Restoration Act, letter from the Family Policy Alliance, a letter from the United States Conference of Catholic Bishops in opposition to H.R. 5, a letter from more than 50 religious faith-based groups writing about the harm the Equality Act does to religious freedom, and finally a Wall Street Journal article I would like to submit to the record.
Without objection.
Thank you, Madam Chair, and I yield back.
Thank you. I recognize myself for purpose of making a closing statement. Thank you again to our witnesses for taking part in this important discussion. Every day, LGBTQ Americans across the country are living without the guarantee of basic civil rights protections. As we heard throughout this hearing, that vulnerability is not merely theoretical. LGBTQ Americans and their families, like Kai and her mother Kimberly, like Ella I mentioned back in Oregon, and millions across the country continue to face discrimination because of who they are. This is wrong, plain and simple. The Equality Act is our opportunity to right that wrong. By amending civil rights legislation to explicitly include gender identity and sexual orientation as protected characteristics, the Equality Act would ensure that LGBTQ Americans can be safe, secure, and free from discrimination. There will likely be a time, perhaps in the near future, when we will look back at this moment with a sense of inevitability. As with many civil rights victories of the past, we will say that history was always on our side and that the guarantee of protections for LGBTQ Americans was only a matter of time. But we must acknowledge that the arc of the moral universe does not bend toward justice on its own. It is our responsibility now, today, it is time, to make clear that all Americans should be able to have full confidence in their rights regardless of who they love or who they are or how they identify. I look forward to working with my colleagues to reaffirm our commitment to civil rights and to forge a country where everyone has the right to be who they are, free from discrimination. And if there's no further business, without objection, the committee stands adjourned.